Good morning, everyone. We'll give everybody a moment to take their seat. Mr. Weigel. Okay, now, good morning. It's a pleasure to welcome everyone here this morning to begin the 12th meeting of the Pennsylvania Public Utility Commission for calendar year 2013, and ask that you join my colleagues and I in the Pledge of Allegiance. The first matter on this morning's agenda is the approval of the minutes from the June 13th meeting, and I'd like to recognize Commissioner Gardner as editor of the minutes. Commissioner Gardner. Yeah, that's what it says.
Thank you, Mr. Chairman. I have reviewed the minutes of the June 13th, 2013 public meeting and move they be approved as submitted.
Second. Any discussion? Any objections? Hearing none, the minutes are approved as submitted. And before I start off with recognizing Ms. Cheryl Walker Davis to commence public meeting here, I recognize my limits as chairman in terms of my ability to run public meeting. And therefore, I think it's appropriate that we retain on waivers Ms. Cheryl Walker Davis to commence public meeting. As my mother once said, you know, she may raise fat kids, but we're not stupid. And we recognize, we're welcome to have back here at the podium our good friend, Ms. Cheryl Walker Davis, to begin public meeting. I know there was a lot of chatter that I was going to get over my skis and try to take on this role, but you know, a man's grasp should never exceed his reach. And on this one, I was truly...
Is that open for comment?
Truly, I recognize the power of Cheryl Walker Davis in running public meeting. With that, I'd like to recognize her this morning to commence public meeting.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items commencing this morning. With matters on behalf of the Bureau of Administration, it is recommended that the commission adopt the recommendation with regard to the assessment on applicable pipeline operators.
So moved. Second. Any discussion? Any objections? Hearing none, the motion is approved unanimously.
On behalf of the Bureau of Audits, commencing on page 2, we recommend the adoption of the items there appearing, just the items through and including the fourth matter down pertaining to the Philadelphia Gas Works audit report release.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
With regard to the release of the audit report pertaining to the Columbia Gas of Pennsylvania, Inc.'s Focused Management and Operations Audit, we recommend the adoption of the Bureau of Audit's recommendation, noting the statement of Commissioner Cawley.
So moved. Second. I'd like to recognize Commissioner Cawley for purposes of a statement. Commissioner Cawley.
Thank you, Chairman. I ask that it be placed on the record as if I had read all of it. I simply want to note that the audit brought to light 3 areas in which Columbia Gas has promised to correct by the end of next year, and I commend them for it. That's it. I will save you the rest. You can read it for yourself.
We certainly appreciate your brevity here this morning. It will be noted.
It won't last.
It will be noted for the record. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting the statement, which you can read at your leisure, by Commissioner Cawley.
We recommend the adoption of the remaining 3 recommendations on behalf of the Bureau of Audits pertaining to the release of audit reports on solar photovoltaic requirement charge riders for Medet, Penelec, and Penn Power.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters on behalf of the Office of Special Assistance, commencing on page 4, we recommend the adoption of the first 2 items through and including the petition for reinstatement of the A1 limousine service.
So moved. Second. Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of staff's recommendation in the proceeding involving the Core Communications complaint against AT&T for the non-payment by AT&T for termination of ISP-bound traffic to Core's end-user customers, noting the statement of Commissioner Cawley.
So moved.
Second.
I'd like to recognize Commissioner Cawley for purposes of a statement. Commissioner Cawley.
Thank you, Chairman. With the majority, I am voting to adopt this settlement, so the vote will be 5-0. And I wish to quibble with just one part. So I'm going to concur in part and dissent in part. Let me talk about the part I quibble about. I represented Core Communications many years ago. It was and is a very small carrier. And like the other small competitive telephone companies that I represented, they struggled against the incumbents to gain a foothold in the marketplace. Core particularly has distinguished itself by spending enormous amounts of money, I'm sure, dealing with competitive issues on behalf of itself and others, not only before this commission, but before the state and federal courts. So I think I can vote for this because even though I represented them many years ago, before I tell you the issue, let me recount what it's like to be a small telephone company competing against very large and well-capitalized companies, and what it meant for customers in Pennsylvania. The first tactic used by the incumbents to fight off competitors is to make it unattractive for customers to switch to a competitor. The usual tactic used was to be very indistinct and mysterious about when the incumbent employee would show up to switch the service. It might be today, it might be any part of today, it might be tomorrow, it might be next week. So the incumbent could make sure that the customer never could count on a time when the service would be switched. And then when the service person would come from the incumbent and open the network interface device, the NID, which has multiple ports, one of which is used by the incumbent, the competitive carrier's service would be plugged into any one of the multiple ports in the NID without any regard to whether it would work or not. And there would never be any check to see whether the service was actually working on the inside of the structure. Very often, the service was not accurately connected, and the rescheduling to do it right would start all over again. And then there would be mysterious disconnections at the central office after service was connected. And then there would be omissions of the switching customers from the white pages or the yellow pages. As Elizabeth Barrett Browning would probably say on behalf of the incumbents, "How do I not love thee? Let me count the ways." And it was always difficult. There would be just infinite number of ways it was difficult for an incumbent to gain a foothold. Our regulations and decisions of this commission have put a stop to a lot of this behavior, and it, for the most part, has ended. But there was always one common tactic that was used by the incumbents, and that was billing disputes, because the competitor would have to lease elements of the system and would always have to pay the incumbent. And the amounts in dispute would sometimes be overwhelming. In fact, one of my clients went bankrupt just because it was owed over $2 million. And it was owed by the incumbent for service and monies that should have been forwarded to my clients. At least two of my colleagues probably have experienced this sort of behavior because they were CEOs of chambers of commerce. Small businesses, when they deal with large financial, well-entrenched incumbents, deal all the time with disputes about money, and the small business can't afford to fight because they just don't have the time, nor can they afford to be distracted by litigation. That's what happened here with CORE. CORE was owed a lot of money, and the issue is, and this is what I quibble about, the issue is whether, now that it's been determined that they were due the money, should AT&T have to pay interest on the amounts that were due all along? We decide in this order that the interest payments will apply only if prospectively AT&T does not pay, as they should. But there shall be no interest on past due amounts, which have now been found to have been due all along. The problem with this, of course, is that it rewards bad behavior. And in the meantime, AT&T has effectively received an interest-free loan on this money for a very long time. I would discourage that kind of behavior because it's one thing if there's a billing dispute with a residential customer, and it's quite another when you have sophisticated business people who are competing against each other for customers. I think there ought to be some penalty for behavior for not negotiating in good faith and not paying amounts and effectively using someone else's system for nothing. And therefore, I respectfully will dissent from that part of our decision which does not award interest for the past due amounts which we have now decided are in fact due. Thank you, Chairman.
Thank you, Commissioner Cawley. Any further discussion? Any objections noting the partial dissent of Commissioner Cawley? The motion passes 5-1, noting the partial dissent of Commissioner Cawley. I appreciate his statement here this morning.
Continuing with the presentation of agenda items in omnibus fashion, it is recommended that the Commission adopt all items appearing on pages 5, 6, 7, 8, 9, 10, 11, and 12 through and including the recommendation with regard to Classic British Limousine Services request for a waiver from the 8 model year rule.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Just a slight correction for the record, Mr. Chairman. I believe that the last vote was called as 5-1 as opposed to 5-0.
5 votes.
Unless we have another commissioner.
You double voted.
Continuing with the presentation of items, it is recommended that the Commission adopt the staff recommendation appearing on page 13. With regard to the United Telephone Company, CenturyLink's annual revenue increase using banked revenues, the Commission entered an order previously by notational vote, and the recommendation, of course, is to acknowledge it for the record. We note the statement of Commissioner Cawley.
So moved.
Second.
I'd like to recognize Commissioner Cawley for purposes of a statement. Commissioner Cawley.
Thank you, Chairman. Again, I ask that my statement be placed on the record as if I had read it in its entirety. This is a settlement agreement between CenturyLink, the Office of Small Business Advocate, and the Office of Consumer Advocate, all of whom in the settlement agreed to disagree about whether an incumbent local exchange carrier can implement a revenue or rate increase on other than an annual basis. In other words, can they raise revenues or rates more than once a year? or must they do it when they file their price stability mechanism? And may they do that more frequently using banked revenues? I mean, as we all know, under Chapter 30 and under these price stability mechanisms, the carrier may receive an increase, but they don't have to implement it in rates. They can bank the revenues. They have a limited period of time in which they must use the bank revenues, and if not, they lose them. The question is, can they raise rates more than once a year? Can they do it outside the price stability mechanism? And that issue was not a part of the settlement. I wish to point out that my view of Chapter 30 is that the amended alternative regulation and network modernization plans that are filed by each of the carriers and approved by us, and the statute itself, I believe, limits the frequency of such revenue increases and rate increases to an annual basis. And that should coincide with its routine price stability index and service price index submissions as set forth in their commission-approved Chapter 30 plan. The calculation and submission of these indices govern the company's ability to seek income-producing revenue and rate increases. And these indexes, or these indices, are calculated and submitted by the commission, or to the commission, only on an annual basis. Thus, the use of banked revenue increases must be coordinated with the annual calculation and submission of these indices. This interpretation, I believe, is consistent not only with Chapter 30 itself and the plans that we approved, but it's consistent with the letter and spirit of the law, which emphasizes price stability. For that reason, I concur in the result only. Thank you, Chairman.
Thank you, Commissioner Cawley. Any further discussion?
Yes, Chairman. I just have a quick verbal statement, and what I'd like to add to the record is that today's action ratifies our prior order adjudicating a settlement and local rate increase request of CenturyLink. And really what's in play here is the applicable law, and I believe that it neither authorizes nor expressly prohibits a mid-year increase based upon bank revenue. To provide clarity on this issue going forward, our order encourages CenturyLink to amend its current Chapter 30 plan if the company wishes to change its annual filing date and implement further revenue or rate increases at a time other than the September 1st PSM filing date. Thank you, Mr. Chairman.
Thank you, Vice Chairman. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting the statement of Commissioner Cawley, who will be concurring in result only, and the verbal statement of Vice Chairman Coleman.
Continuing now with matters on behalf of the Bureau of Technical Utility Services, commencing on page 14, it is recommended that the Commission adopt all items commencing with the application of Hess Corporation at the top of page 14, and continuing with all of the items on pages 14, 15, 16, 17, 18, 19, 20, 21, and 22, through and including the recommendation pertaining to the application of Coleman Enterprises, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Turning now to matters presented on behalf of the Law Bureau, commencing on page 23, it is recommended that the Commission adopt the first recommendation with regard to Tatkatel, Inc.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
We recommend the adoption of the next two items pertaining to the reconciliation of pass-through transmission costs and revenues relative to PPL Utility Corporation's default service classes, as well as the recommendation pertaining to the transmission service charge reconciliation method recommendation, noting the separate statements of Commissioner Whitmer with regard to those matters.
So moved.
Second.
Commissioner Whitmer, I believe you have a conflict statement you'd like to have entered into the record.
I do. Thank you very much, Mr. Chairman. I would like my statement, as you noted, entered into the record as if I had read it in its entirety. Prior to joining Team Whitmer, Shelby Linton Ketty was employed by a law firm, during which time she served as counsel for record for PPL Industrial Customer Alliance in this proceeding. So therefore, to avoid any impropriety arising from her previous employment, I note that she has not been involved in advising me regarding this matter. Thank you.
Thank you. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting the conflict statement issued by Commissioner Whitmer.
Continuing on behalf of the Law Bureau, we recommend the adoption of the recommendation pertaining to the final rulemaking order in the proceeding involving the licensing requirements for natural gas suppliers, noting again the statement of Commissioner Whitmer.
So moved.
Second.
I'd like to recognize Commissioner Whitmer for purposes of a statement.
Thank you, Mr. Chairman. I'd like my statement entered into the record as if I had read it in its entirety. Before us today is the final rulemaking concerning revisions to the Commission's requirements for natural gas supplier licensing that chiefly removes the licensing exemption for marketing services consultants, establishes new definitions, and clarifies the natural gas supplier licensing requirements for aggregators and brokers. These changes better reflect the statute as well as current business standards and practices. Importantly, these changes also provide better symmetry and continuity between the treatment of licensed entities on the electric side with entities subject to our natural gas supplier licensing requirements, both of which are providing the same service to the competitive market. When the Commission first initiated this rulemaking process in 2011, I thought it necessary for the Commission to periodically review the Public Utility Code and our regulations to ensure that their purpose is being properly effectuated. I continue to believe that today. I want to commend the good work of staff as well as the thoughtful comments received that resulted in today's final rulemaking. This rulemaking recognizes the important role of that aggregators and brokers have come to play in the natural gas competitive retail market and provides more clarity to the natural gas industry and more transparency to consumers regarding what is expected of these entities. Furthermore, using similar terminology across the electric and natural gas industries will reduce customer confusion and will allow companies that supply or sell both commodities to more easily market their products across the Commonwealth. I remain steadfast in my belief that a functioning natural gas competitive retail market represents an economic opportunity and that this Commission should continue to actively explore ways to remove barriers to retail natural gas competition. I look forward to working with all interested parties going forward to further strengthen the state of natural gas competition in Pennsylvania. Thank you, Mr. Chairman.
Thank you, Commissioner Whitmer. Any further discussion? Any objections? Hearing none, the motion passes unanimously, noting the statement of Commissioner Whitmer.
It is recommended that the Commission adopt the final rulemaking order with regard to the elimination of additional paper copies, the increase in size limits for qualified e-file documents, and dispensing with the requirement for paper copies for e-file documents of less than 250 pages.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Continuing on to page 25, it should be noted with regard to the proceeding involving the interim guidelines for natural gas distribution companies' eligible customer lists, there was the joint motion of Commissioners Whitmer and Cawley.
I'd like to recognize Commissioner Whitmer for purposes of the joint motion with Commissioner Cawley. Commissioner Whitmer.
Thank you, Mr. Chairman. Commissioner Cawley and I would like our joint motion to be entered into the record as if we had read it in its entirety. Before the Commission today is a final order outlining interim guidelines that are aimed at providing greater uniformity in the customer account information provided by natural gas distribution companies to natural gas suppliers. The guidelines support the Commission's ongoing efforts to further develop the natural gas competitive retail market. Moreover, the actions in today's order seek to more closely parallel similar guidelines recently issued to electric distribution companies and electric generation suppliers. While we agree with the bulk of the order, including the major recommendations, we also believe that a further refinement is needed to better remove barriers to natural gas competition. Rather than forego the requirement of having natural gas distribution companies resolicit their small commercial and residential customer base on a dedicated mailing on at least a triennial basis, we believe such a focused mailing is needed in order to ensure that the eligible customer list is refreshed so that information available to natural gas suppliers does not become stale. Additionally, upon further review of the electric eligible customer list order, it's come to our attention that while we determined that in lieu of annual company-wide solicitations, EDCs shall actively notify customers of their withholding options through each new customer's welcome package and through periodic announcements in customer bill inserts, email, or a separate announcement included in the customer's paper bill or electronic notification if available, we failed to institute any sort of dedicated solicitation to refresh an EDC's eligible customer list on a company-wide basis. Accordingly, as part of this motion, we suggest referring this issue to the Office of Competitive Market Oversight for discussion by its charge group in order to explore the necessity of such a requirement for EDCs. Therefore, we move that Law Bureau prepare an opinion and order consistent with this motion. Thank you, Mr. Chairman.
Thank you, Commissioner Whitmer.
Second.
Any further discussion? Any objections? Hearing none, the motion passes unanimously. The joint motion passes unanimously.
It is recommended that the Commission adopt the next item pertaining to the Law Bureau's recommendation in the proceeding involving the petition of Columbia Gas Company pertaining to the use of refunds received from Columbia Gas Transmission.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Should be noted that the last item on the Law Bureau's agenda pertaining to the elimination of the motor carrier need requirement, the rulemaking pertaining to 52 PA Code Chapters 3, 5, 23, 31, 32, and 41 has been postponed until public meeting of August the 29th. Continuing with the presentation of agenda items and matters on behalf of the Office of Administrative Law Judge, it is recommended that the Commission adopt the two items appearing on page 26 through and including the rate increase request of the Imperial Point Water Service Company.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
With regard to ALJ Colwell's initial decision in the proceeding involving Marcia Shapiro versus Philadelphia Gas Works, there is the motion of Commissioner Gardner.
I'd like to recognize Commissioner Gardner for purposes of the motion. Commissioner Gardner.
Thank you, Mr. Chairman. I'd like for my motion to be entered into the record as if I read it in its entirety. On July 30th, 2012, Marcia Shapiro filed a complaint against PGW alleging that she should not be responsible for paying for gas for a 20-day period in January of 2012. On January 2nd, 2012, Ms. Shapiro reported smelling gas to PGW, Philadelphia Gas Works. PGW inspected the resident but found no leak. During a second inspection 20 days later, PGW found a gas leak associated with Ms. Shapiro's hot water heater. In her complaint, Ms. Shapiro alleged that her January 2012 bill was not accurate as she had not used gas for 20 days because of her concern about the gas odor. The evidentiary record produced in this proceeding showed that not only was the January 2012 bill incorrect, the 6 bills issued during the latter half of 2011 were also incorrect. Philadelphia Gas Works acknowledged that the erroneous bills were caused by a system problem. When prompted at the hearing to explain the system problem, Philadelphia Gas Works could not. By initial decision issued on April 30th, 2013, ALJ Colwell sustained Ms. Shapiro's complaint on the issue of incorrect billing. The ALJ noted that under the civil penalty analysis historically used for all Pennsylvania utilities except PGW, the result would have been an assessment of a $1,000 civil penalty. However, based on the Commission's policy of not assessing monetary fines against PGW, the ALJ did not assess the civil penalty. Beginning in 2008, and due to PGW's unique position as a city-owned utility that had no shareholders, combined with PGW's precarious financial position at that time, the Commission chose to handle violations in a manner that would preserve PGW's financial viability. By not levying penalties against PGW, the Commission also shielded PGW's ratepayers, Philadelphia taxpayers, from an additional financial obligation on top of those that they already face. PGW is no longer in crisis mode that it was in 2008. Accordingly, the Commission will no longer abstain from leveling civil penalties against PGW. I agree with the ALJ's analysis that a civil penalty of $1,000 is an appropriate sanction for the unexplained billing error in this proceeding. Additionally, although the gas leak itself was not an issue in this proceeding, I wish to remind the company of our action taken on the July 16th public meeting with regard to the advanced leak detection pilot. I ask that PGW make that leak detection pilot a very high priority. Therefore, I move that the initial decision be modified to levy a $1,000 civil penalty against PGW consistent with this motion, and that the Office of Special Assistant prepare an opinion in order consistent with this motion.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Continuing with matters on behalf of the Office of Administrative Law Judge, it is recommended that the Commission adopt the remaining recommendation on page 27 as well as all items appearing on pages 28, 29, and 30 through and including the recommendation pertaining to PPL Electric Utilities Corporation Act 129 compliance rider.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
With that concluding the regular agenda, we turn now to the carry-in agenda. It is recommended that the Commission adopt on behalf of the Office of Special Assistance the recommendation pertaining to Canadian Pacific Railroad.
So moved.
Second.
Any discussion? Any objections? Hearing none, the motion passes unanimously.
Mr. Chairman and Commissioners, that does conclude the presentation of agenda items.
For purposes of video, I almost said video conferencing, of the taping of today's public meeting, we're going to adjourn the meeting, but I want to recognize the Vice Chairman to recognize a very special initiative that this commission was involved with, which was our innovation event with the Innovation Expo with Governor Corbett and the innovation team here in the state. So we're going to adjourn public meeting, and then I'm going to turn it back over. Is that correct, Fred? Okay.